in 200 miles, I know that. And I will.
All right.
I'll watch my son back.
Good afternoon, everyone. We're going to call this May 5th, 2025 Board of Adjustment to order. And I have some rules to cover for you, and then we'll proceed with the roll call. First, if you've got any electronic device, I'd ask that you turn it on silent or off so that we don't have a disturbance during the meeting and for the board as well. And reminder to the board that when you make a statement, that you remember to turn your mic on. And we have a different little layout here today. Most of us sit on that first row, and since we have all members here, with exception one at the moment, we had to kind of spread out a little bit, so it's a little different for us as well. If you have any handouts, I would also ask that you give those to staff so that we can disseminate those now and not have to stop during the meeting if you have anything for the board. All right, so let me go through the basic rules of the boards. So when a applicant comes to the podium, you got to give your name and address for the record. We allow 4 members to speak in support of an application with 5-minute limitation for each, and then 4 in opposition, and then 1 remaining minute allotted to each of those as the time's winding down. So it'll give you a reminder that your time's up and you need to conclude your statements. And then the applicant gets a 2-minute rebuttal. And then at that point, unless there's questions or comments, then we'll conclude our public hearing and go to the deliberation of the board. If you have questions regarding the board's decision, you call Planning Commission at 251-208-5895. And I have the luxury as chair to extend time based on questions or interruptions we may have throughout the applicant's request. And let's see here. It takes 5 members to affirm a motion, either in support or opposition. And it appears to have enough members present for a quorum, so that normally is a requirement as well. All right, and with that, I will go with a roll call, starting with Mr. Metcalf. He's not here at the moment. Mr. Golden? Here. Mr. Milling? Here. Mr. Carroll? Here. Mr. Morris? Here. Ms. Farrell? Mr. Atchison? Mr. Williams? And I'm William Guess. So we have 2 supernumeraries, Mr. Atchison and Mr. Williams. They are both present and have at times the opportunity to represent one of the 7 voting members if one should recuse himself or be absent. And I would also like to introduce 2 new members, Ms. Farrell. She's new to the board as of today, and Mr. Williams, a supernumerary. And based on the numbers present, we have a quorum and we can proceed. And hopefully Mr. Metcalf, who's vice chair, will have the opportunity to join us shortly. So as chair, we also have the option of changing the order of the agenda if necessary based on attendance or the time I think it will take for an application to be discussed or a particular agenda item. So I may change that as we go through this agenda. So starting with application 6664, 6423 regarding 750 Congress Street. My understanding is the applicant's requesting a holdover. Is that correct?
Madam Chair.
Yes.
I think we need to bring some of the new members up to speed as to their capabilities of handling the iPad. Ms. York?
Oh, we're having issues with the iPads?
Yeah.
Thank you, Mr. Morris.
Mr. Guest, while she's doing that, yes, the opposition, Mobile County Health Department did send a letter wanting to delay this for a month, and they have some issues with it. The attorney, once the attorney for the applicant in Birmingham received that letter, he called me Friday and asked, he said he's agreeable to hold over. Did he need to drive down just for this? I said no. Since the other side's requesting it and you agree to it, I'm sure the board will hold it over to give them time. They have not discussed it between the two of them.
Okay. All right. And for those that are in attendance today, is anyone here that was either in support or opposition? I wanted to give you a chance to speak if you had any comments. Okay, we have none for the record. So the applicant's going to request a holdover to meet with the health department. And with that, Chair, entertain a motion.
I make a motion, Mr. Chair, to hold it over.
Okay, do I have a second?
Second.
Have a second. Any further discussion? All those in favor of the motion say aye.
Aye.
Anyone opposed? Motion carries. All right, we'll go to application 66, 65, 59, 58, 51, 57, 47, 4782 regarding 1739 East I-65 Service Road. Will the applicant come to the podium? Good afternoon. Your name and address?
Good afternoon. Address is going to be 1739 East I-65 Service Road South.
All right, and you want to tell the board why we should consider your application, please?
Yes, sir. So it says here that we're replacing 4 freestanding signs, but we're actually only replacing 2 freestanding. The other 2 additional signs are actually attached to the building. One sign is the Dean McCrary name on one side of the building, and the other sign says Mazda with a Mazda emblem. Those are affixed to the building. The other one is going to be the monument sign in the front yard, which currently does have a Mazda logo on it. That one stands about 25 feet tall. The new one is about 35 feet tall, so it's going a little taller. But these are signs that Mazda, for our compliance with them, has stated that we have to replace. The current signs have been there over probably 15 years. They're blue signs, and Mazda's new logos are black and silver. So they are requesting that we replace our old signage for new signage. The other freestanding sign is going to be a 3-foot, 4-inch tall by 4-foot, 10-inch service sign that will replace a outdated old service sign that is currently there. So it's not going to be anything that's like brand new, that's never been there before. We're literally just replacing old signage for new signage to be compliant with Mazda manufacturing.
Okay, any questions of the board for the applicant?
Question, with that change to the application and just considering 2 signs, are they in compliance? Is there a need for a variance at this point?
Yes, sir, because while they're not replacing all 4 signs, they do have more freestanding signs on site than they are allowed overall.
Thank you.
Okay, what would be the purpose of the height increase for the one?
It's just the only sign that Mazda makes. So from what my understanding is, the actual poles that go up, all that's still the same, but it's literally just their sign that is a bigger sign that they want to put in. So from my understanding from Mazda is looking at all their other signage that has been put out elsewhere, it's just a taller sign overall. That's what I've been told.
Okay, staff, is there any issue with the height?
The height of the proposed sign is allowed by right.
Okay,
It's just that it is increasing over the height that was previously approved by the board.
okay. Is there any public comments either in writing to the staff?
No comments were submitted for this application.
Okay,
Do we know what the typical square footage is of those signs up and down the service road for the dealerships? Is this going to be consistent or bigger?
There has been a history of variances granted for dealerships along the service road to go with their national branding packages. So I couldn't say off the top of my head what that square footage would be, but there has been that history.
Okay. Any questions of the board, once again, for staff or for the applicant?
I would like the speaker to say his name. I don't think that we got that for the record.
So sorry about that. My name is Andrew Inger. I'm the general manager of the store.
Okay, thank you.
Thank you.
All right. Do we have anyone in support or opposition to the application today? Okay, that concludes the public hearing. Any discussion of the board, comments? Okay, hearing none, Chair will entertain a motion.
Mr. Chair, I'll make a motion to approve, subject to findings of fact.
Okay, do I have a second? I have a second. Ms. Morris, turn your mic on.
Second.
All right, thank you. I have a second. Any further discussion? All those in favor say aye.
Aye.
Anyone opposed? Motion carries. All right, application 6666, 5118, 5047 regarding 270 Beauregard Street. If the applicant will come to the podium, please. Good afternoon. Your name and address, please.
Yes, good afternoon. My name is David Brandt. Address is 133 West Park Drive, Birmingham. Here to represent our client, Gulf Distributing, in the matter of signage variance. With the acquisition of this new building comes a building renovation effort, a landscape renovation effort, and also with that, a need for signage. And so this is a 17-acre facility, and with it comes certain signage needs that go a little beyond what's allowed per code. And so has everyone had a chance to see all the drawings and the scope? So getting right into it, what you're seeing here is a one-sided monument sign. We're about 2 square feet above what's allowed here. Code says we can have a 25 square foot monument sign on the property. This is a 27.1 square feet. What it is doing is not only labeling the main tenant, Gulf Distributing, but 3 other smaller office tenants that would be that would have rights on this sign as well. So it does have a multi-tenant function. But in order to make that work on this particular monument sign, it would be we would need just a couple more square feet than 25 in order for that proper visibility. What you'll see is that it actually is integrated into the fencing, into the along the edge of the property at the corner of Beauregard and Water Street. And again, it is one-sided. So that would be one of the variance requests, is that I need a slightly more square footage on that one monument sign. Over here on the northwest corner of the property facing Beauregard Street is a set of address numbers that we're proposing. These are non-lighted letters, set of address letters that would be placed towards the top of the building. Code says that an address sign at this building can be 1 square feet and has to be low to the ground and near a primary entrance. We're trying, this is between a 16 and 17,000 square foot facade alone facing Beauregard Street. We're trying to put something on the building that has better long distance visibility and identifiability rather than just a number. We are proposing 270 Beauregard Street, so it is clear what the exact address is for the property. There was discussions with the fire marshal and my client regarding letter size requirements based off of site distances, and based off of site distances primarily off of Highway 165 headed south towards the property, and other viewing perspectives surrounding the property. It would yield a 13-inch tall letter size, which is actually exactly what we have the sign drawn at. So those are, and it's a 17 square foot sign instead of a 1 square foot sign. And so the request is that you allow us to have something more than 1 square feet, something that is not directly next to the entrance. And those would be the variance requests regarding that sign. Moving over to, I'll direct you to the sign on the building, which is kind of on the bottom left of this page here. There are other renderings as well that were provided. This is a better one. This is a shot of the building sign that you would see off of the, as you come down Highway 165 as you approach the building. We are asking for a sign that is lighted, but instead of light coming out of the face of the sign, it would be just an accent halo lighting that would offer better readability when it gets darker out. So instead of sort of a retail-looking face-lighted sign, which I know is not desirable in this area, that we would just have something that you could better read from a distance at night. And so the other part of the variance is that this sign is supposed to be linear in orientation rather than stacked, as you see there. We're trying to provide something that makes more sense from not just a visibility standpoint, but from an aesthetic standpoint. There is a rendering that also shows the sign in context where you see a series of vertical bands on the sign. What we're trying to do is stay within one of those light-colored vertical bands that you currently see it on now. It's just a partial elevation that you're seeing, but basically that allows for better readability as opposed to the sign spanning across the different bands and the different colored bands. It makes more sense from a visual standpoint and from a readability standpoint.
Okay, we had time. If you can summarize.
Yes, sir. So if you keep flipping through, that we do not need a variance for that sign, as I understand it. That meets code. The last sign that we're asking for is a directional sign that is, it's monumental in design. We're trying to do something that offers more opportunity for directional information. It only yields 3-inch tall letters, but because it's a monument style, we are needing to ask for a variance for a second monument sign. Yeah, and yes, that sign is actually an exact replacement of something that used to be there that was damaged years ago by a vehicle.
Okay. All right. Any questions for the applicant?
I've got just one, Mr. Chair. David, the multi-tenant sign, are there tenants already that are lined up for that? Is that going to be just lease space, or are they other businesses under Gulf Distributing? Or
They are going to be leased spaces, office spaces, independent of Gulf Distributing.
Gulf Distributing?
Yes, sir.
Okay, thanks. Do you know how much square footage, plus or minus?
Of the,
Hey, I'm Robert Bronstein with Gulf Distributing and Adams Street Property.
If you'll give your address as well, please.
Yeah, 3378 Moffett Road. And we do not currently have tenants lined up that we can share, where those conversations are in the works. There's approximately 80,000 square feet of tenant space, probably 35,000 of which Gulf Distributing is leasing in the office space.
Okay.
That might be subject to change, but.
All right. Any further questions? All right. Any other questions of the board for the applicant?
Mr. Chairman, it was brought
Yes.
to my attention that on the previous vote, everybody voted. We only need one supernumerary to vote, so your choice of which one
Well,
votes.
Mr. Allen's new, so we'll let his vote be the casting vote. All right. Once again, any questions of the board for the applicant? All right. Do we have anyone that would like to speak in support of this application? Anyone in opposition? Do we have any correspondence?
We do not. I do want to just clarify one item in the application. This particular sign, the applicant said that they did not believe that they needed a variance for. However, in the CRC review, this sign was classified as a wayfinding sign, and as such is limited to a maximum of 5 feet tall. This sign is proposed to be 7 feet tall, so that's the need for the variance on that particular sign.
Okay.
And just a point of reference, if that's drawn at 7 feet tall, we can actually, if you see the scale, that's a 6-foot person right there. We can bring it down to 6 feet.
Okay.
Happy to do that. Or 5 feet. 5 feet would be suitable. The less variances, the better. So we would be happy to bring it down to 5 feet.
Okay, so the wayfinding sign could be reduced to the 5-foot height, which would eliminate the need for a variance?
Yes, sir.
Okay. All right, and the address, what was the height of the address sign?
13-inch tall characters.
No, the height of the sign itself.
Off the building, I believe that's somewhere to the tune of 40 feet.
No, address. Wasn't there a freestanding sign with the address on it?
I don't believe there used to be a sign with a freestanding
Oh,
sign.
no,
with the
never
address.
mind, it's on the building, I'm sorry. I just glanced at the photo, it's actually on the top of the building
Yes, sir, that's right.
for the fire department. Okay. Any other questions for the applicant? And the Golf Distributing Company sign that's on the side of the building, that's within, for staff, Marie, is that within the size limitation, or is that larger than required as well?
For the wall sign that's on the conveyor
Yes.
there, the overall sign is larger, as well as they are limited to 1 line of text. And so they have 3 lines of text and exceed the overall size
Right.
allowance.
And he was explaining that as
in
it
addition
relates.
to the internal illumination.
Okay. All right. Once again, any questions of the board? All right, that'll conclude our public hearing regarding this application. The one sign will be reduced to the 5-foot standard, which will eliminate the need for a variance for it, which will leave, 3 for the board to consider? 4? All right. With that, Chair, entertain a motion.
Mr. Chair, I do think that, due to the size of the building, and especially the amount of wall space, that aesthetically, I think allowing larger signs on this will be more in proportion and look better. From that standpoint, and subject to the other findings of facts, I would vote to approve the remaining sign variance requests.
Okay, I have a motion to approve, subject to findings of fact. Do I have a second?
Second.
I have a second. Any further discussion? All those in favor say aye. Aye. Anyone opposed? Motion carries. And with that, Mr. Atchison, his vote will be utilized for supernumerary. Okay, and.
Thank you all very much.
Yep, thank you. All right, now we're going to change the order up a little bit. We're going to save application 4 to the end because I think that's going to take us a little more time to work through. So we'll go to application on our agenda number 5, which is 6668, 6580, 6550 regarding 6109 Howells Ferry Road. If the applicant will come to the podium, please. I think we're getting to know you folks.
I'm glad you recognize it.
For a matter of record, your name and address, please.
My name is Claude Hall, address 812 Brighton Place, Mobile.
Okay, and your name, please?
Melody Hall, 812 Brighton Place, Mobile, Alabama as well.
Okay, and staff, refresh my memory, there was a change in the site plan,
Correct.
so therefore a previous approved variance has to be reconsidered.
Correct, yes, sir, since approvals are site plan specific.
Okay. So you want to tell the board what has changed that we need to consider the variance today?
Well,
And I guess we'll get your name and address.
I'm Jackson Berkbigler with Rowe Engineering, here on behalf of the applicant.
Did we get your name?
Oh, sorry, what's that?
Your name?
Jackson Berkbigler.
Okay. Thank you.
Thank you. The main thing that really changed here was just the parking layout. We've applied for our land disturbance permit, got some comments, added parking islands. Nothing changed with regards to the proposed building sizes. So while the changes were minimal, it was still technically a change in the site plan.
Okay, give me a second here. I'm having a hard time getting this to go back. Come on. So mainly the site plan and the parking?
Yes, all the changes were related to the site work thus far.
Any questions of the board for the applicant? All right. Do we have any public comments regarding this one?
is the daycare, it's being run by the church? Or is,
No, we currently run a daycare about a mile and a half down. The purpose of this was so that we could stop renting from the church that space and acquire our own space for, moving forward.
gotcha.
Okay, any other questions for the
Thank
applicant?
you.
Existing parking proposed. So what was the primary change again on this, in the parking? I'm looking at the drawings.
Really just the number of spaces to meet the requirements in the UDC, adding landscape islands at the frequency as required by the UDC. I think that's really it.
Okay.
Addition of sidewalks internally.
I don't remember the detention pond previously, but that may have been on there. Okay, any other questions of the board? Okay, Marie, do we have any public comments this time?
No, sir, we did not.
All right,
And just for the record, Mr. Chairman, I hate to keep butting in, but the staff report says this is an amendment. It's not, because both prior variances have expired, so there's no pending variance. So this was really a brand-new application.
okay. So it's a variance request as normal. All right. Anyone in the audience either in support or opposition to the application today? Okay, we have none for the record. You folks can have a seat. That concludes our public hearing regarding the application. As mentioned by Mr. Anderson, this is to be considered a new variance request based on the updated site plan. And with that, Chair will entertain a motion.
Motion to approve.
Yeah, I have a motion approved, subject to findings of fact. Mr. Morris?
Yes.
Okay, do I have a second?
Second.
I have a second. Any further discussion? All those in favor say aye. Aye. Anyone opposed? Okay, motion carries. And hopefully you all can get started. All right, motion carries. All right, let's go to application 6, which is 6669 regarding 5399 US Highway 90 West. If the applicant will come to the podium, please. Your name and address, please.
Hey, good afternoon. Jacob Franklin, 11 North Water Street. I'm here to propose a setback variance for placement of a trash enclosure within the building setback.
Okay.
Currently, this site is an existing unoccupied bank facility. Proposed improvements consist of complete demolition and reconstruction of a C-store and fueling station, as you can see. Reason for the placement of the trash enclosure within the setback, as you can see, the site is locked to the east by a private access drive, which currently serves a multitude of businesses in this corridor, and that access cannot change. To the west, the site is locked by an extensive DOT right-of-way. There's an existing ring road there to the west you can see, which will be closed off in the future. So right now, the site is approximately 120 foot away from the travelway of US Highway 90. So while within the setback, there's a clear organic buffer there. Really, due to those constraints and the required widths of the access drives for fueling trucks and delivery trucks, the placement of the trash enclosure is really the only place it could be for the site. So the enclosure itself is an 8.5 foot tall enclosure consisting of a masonry and stucco finish, which does match the parent structure. Currently, the enclosure itself is approximately 6 foot off of the west property line there and approximately 13 foot from the north property line. So within both of these setbacks.
Okay. Any questions of the board for the applicant?
Yes, Mr. Chair.
Yes.
So, and I was out this way earlier today, and I know there's some planned improvements for that corridor.
Mm-hmm.
And I think I have some concern for where, that's kind of putting it on the front corner of the property. And I just, it sounded like you had run other alternative site, whereas, but I looked at the racetrack, the Murphy, there's a number of other fuel stations along in there, and I got to think there's a better spot to put it than on the front corner.
Yeah, several iterations have been done here. If you don't mind, zoom out just a little bit. I'll show you. And we thought about the southeast corner there, but if you see that the property line divots and bumps up and over, really we can't place it there. That would cut that access off. The northeast corner is kind of the same story. And if we placed it on those internal property corners, the access would be less than 15 foot in width, which doesn't really allow for circulation of either fuel or delivery. And that southwest corner, you see there's an existing sign there that will stay. Mm-hmm.
You could reduce the size of the building, correct?
This is a end user prototypical. This is the space that it is.
Any further questions? This is a very busy site with all these access roads and the way the parking lot interconnects. So I could see it can be difficult. Like Mr. Golden said, I'm trying to figure out a different place to put it as well. And the air pumps and all that's in an area that's all part of the end user's design.
That's correct, yes. And even, if the trash enclosure if we attempted to relocate there, that conflicts with the underground storage tanks as well as the alignment of the trash truck trying to get there. So
yeah,
it really needs to be along a north-south or an east-west as it fits for back end.
Okay. All right. Any other questions of the board for the applicant? Okay, do we have public comments regarding this application?
No, sir, we did not.
Okay. Do we have anyone in the audience either in support or opposition today? All right. Thank you, sir.
Thank you.
That'll conclude our public hearing regarding the application. Discussion of the board. Okay. Concludes our public hearing. Chair, entertain a motion.
If I might this is a really unusual situation because this property is really on an island. It's got 4 streets on all 4 sides, so no matter what corner you're going to put it in, it's going to be visible. And people can drive right by it, wherever it is. It's not like it has a backyard.
And I can agree. I mean, even the Murphy fronts Halls Mill and 90, and it's on the sort of the secondary access. And I just have to, I have to think there's a spot. Yeah. Because there's a lot of traffic that goes through there internally that, I mean, if you put it where it inhibits vehicular traffic, and sight lines, that's a problem too. I just have to wonder, looking at this loading zone or the corner where there's some spots, I mean, would they have an access through there if there's a alternate site? I'm not an engineer.
Well, and the other part of it is truck access. If you don't put it in the right place, then the truck can't get to it. So, all right.
Mr. Chair, I'll make a motion, I guess, subject to getting the cold shoulder from my compatriot here. I'll make a motion to approve, subject to the findings of fact.
Got a motion to approve, subject to findings of fact. Do we have a second?
Second.
I have a second. Any further discussion? All those in favor, say aye.
Aye.
Anyone opposed? Motion carries. All right. Ms. Golden, did you vote in opposition? You did, okay. All right, we have that for the record. All right, let's go back to number 4, which is administrative appeal. Good afternoon.
Good afternoon, Carrie Kamanis with Helms and Leach for the applicants Carrie and Charlotte March. Address is 150 Government Street. So we're here on an administrative appeal where the staff determined that the subject site is not entitled to legal nonconforming use as a short-term rental. One of the reasons was that the belief that this determination would apply to every pre-existing short-term rental in the city. And there was also a comment in the denial letter that the legal department had determined that short-term rentals were not eligible for nonconforming status. I'd like to take a step back and walk through what's going on at this property for a minute and give you a little bit of a history on the property. The house was built in around 1900. I think I sent a letter on Friday that said 1910. I've confirmed with our client, though, it was 1900. The guest house, this 2-story carriage house, guest house, back house, garage apartment was built at the same time. The current applicants purchased the property in 2006. From 2006 through 2018, they rented the back house. In 2018, they switched their rental model to short-term rentals, which they've been doing successfully since that time. In 2019, they began remitting lodging taxes to the city of Mobile. And the short-term rental ordinance, as y'all realize, there was a lot of back and forth. The city's been, I think, contemplating how to handle short-term rentals for a number of years. The current ordinance did not go into place until March 1st of 2023 with the adoption of the UDC. And then almost a year and a half later, the city determined that they were going to start licensing short-term rentals, and they sent out a business licensing letter, which my client received, asking them to get a license and directing them to the city department, the planning department, to apply for appropriate zoning. At that point in time, we got involved and looked at the current code and determined that we believe that you could apply for non-conforming use. And part of that is because in order for them to have non-conforming use status, you look at the regulations that were in effect at the time they began the use. So in this instance, we have to go back to the code that predates the UDC. I think there is no question that any new short-term rental has to come into compliance with the UDC. The issue here is that this back house was being used as a short-term rental for almost 5 years before the UDC went into effect. It's the house itself, as I already mentioned, there's 2 dwellings. There's the main house and then there's the back house. So when we go and we look at the 2018 code, in the 2018 code, there was no prohibition or direct prohibition on short-term rentals or any rentals. The code contemplated the house is located in the site is located in a single-family dwelling neighborhood. The code contemplates, as does our current code, that single-family neighborhoods can have duplexes or two-family dwellings. We're all aware that all over Midtown, there are houses with back houses. In 2018, the single-family dwelling residence was a building containing one dwelling unit for residential purposes to be exclusively used by one family. One family, however, can have up to 4 boarders under the code or tenants. Also, accessory uses were allowed under the 2018 code, and the accessory use was allowed by right. So again, it's our position that the rental of the guest house was a use that was allowed under the 2018 code, and therefore were entitled to non-conforming status.
You can continue.
Okay, so the other thing that's interesting about the 2018 code is that there's no strict prohibition on uses not listed. There is a system, there's a process under the code where you could have gone forward and said, well, is this use at this particular location allowed because it's not in the chart of permitted uses? Again, we can all agree that short-term rentals were not in the chart of permitted uses prior to the 2023 adoption of the UDC. However, the city acknowledged that as well, and throughout this time, the applicants were never cited for notice of violation. They've never been told that their use was not in compliance. And they've also remitted lodging taxes throughout that time, which the city accepted, which would indicate that their use was lawful.
Okay. Any questions of the board for the applicant or for the representative?
Yes, sir. I have currently, are they using it as short-term rental?
They are, yes. It is listed on the Airbnb platform, and their lodging taxes are remitted in conjunction with that use.
Okay, thank you.
So,
Okay. Any other questions? Okay. Sir, you have something to add?
Yes, thank you. Casey Pipes, also with Helmsing Leach, 150 Government Street. We can't get it all in 5-minute increments, so we divided it up a little bit. One of the, this isn't. No, but we're not asking for more time, just trying to cram it in.
We'll make it work.
Mobile's not the first town to pass a zoning code that deals with short-term rentals. There's some cases out there about this from other jurisdictions. And one of them is the City of Auburn case that you may be aware of or that you may hear about here shortly. In Auburn, they had a property owner that was trying to get non-conforming status because they passed an ordinance that prohibited short-term rental. He was renting his basement, and the case holds that he's not entitled to that legal non-conforming status because his use was never legal in the first place. He was in what they had in Auburn was a neighborhood conservation district, and it specifically prohibited you from doing anything like a short-term rental before they changed the code to specifically address short-term rental as a separate type of use. So he was asking for legal non-conforming status for a use that was never legal. And, and so the case goes up and you get a reported opinion saying that the city was right to not give him that status and to enforce the ordinance. Here it's different. We had an accessory use. We didn't exceed the number of people you could have in there. And we were, just like everybody else, we were renting, the client was renting out a back house, which is probably happening thousands of places around the city. They didn't have a durational requirement to the rental. If you can rent it, but if it's more than this number of days or that number of weeks. It was before that, before people started regulating it, short-term versus long-term rental. So we had this use in existence. I don't think there's much dispute about it because the city was getting the lodging tax during this period before the UDC was adopted. And we've still not heard any explanation from the city as to why it wasn't legal at the time it was being done, just that our request for legal non-conforming status was denied because the legal department doesn't feel like anybody's entitled to that for this type of use. And we think that's clearly wrong, and that's why we're here asking for the board to, on an appeal of that determination, so you can recognize the legal non-conforming status of the short-term rental.
Okay, any questions from the board?
I've got a question for staff. Can you all elaborate on the position after hearing their explanation of why they believe they had non-conforming status? Is this something that was decided at staff level, or was it a decision made in a different department? Joe?
All right,
I've called to the bullpen, and Mr. Rossler, who's another city attorney who's helped write this ordinance, is going to speak.
okay. Before we do with Ms. Rossler, did we have anyone else that was in support of the appeal? Okay, we have none. Please, Ms. Rossler.
Thanks, sir. Jim Rossler, 2124 Marchfield Drive West, staff attorney for the city. I have the honor and privilege today, as I have for a number of years, of working with the planning and zoning staff and representing them here today. Let me first answer a couple of questions raised by the applicants. In today's presentation, they argue that this is an accessory use. In the letter that they submitted late Friday afternoon, they argue that this guest house / garage apartment is an accessory use. In that letter, the applicants state that the property is comprised of lots 1, 2, and 3 of Park Place subdivision. The guest house garage apartment sits on its own lot of record. That is a quote from the applicant's submission that was made on Friday. The guest house garage apartment that is used for short-term rental purposes sits on its own lot of record east of the main house. The applicant then argues that it's a short-term, that the short-term rental is an accessory use to the main house. However, if you go back, look at the definitions in the zoning ordinance, the old one, and the UDC, accessory uses must be located on the same building site as the principal use. You can't have a principal use on one lot and then on a separate lot of record have another structure and say, well, it's an accessory use to this one. They all have to be. The main use, in this case, the main house, and the accessory use have to be on the same building site, i.e. the same lot of record. Therefore, by the applicant's own admission, the guest house garage apartment that they use for 2 short-term rentals is located on a separate lot of record and therefore does not qualify as an accessory use. Secondly, I'll come back to this in a little bit, but both Mr. Pipes and Ms. Kamanis mentioned the payment of lodging tax. Lodging tax has been required by the state of Alabama for hotels, short-term rentals, any other type of transient places where people come and stay for short periods of time for quite a while. The the applicants use the Airbnb platform as their rental platform for these 2 rentals that are in the garage apartment. Airbnb entered into an agreement with the city of Mobile in 2019 after they started using this garage apartment as short-term rental. Airbnb entered into an agreement where Airbnb collects taxes from whoever rents on their platform and submits a lump sum payment each month to the city of Mobile. on an anonymous basis. So when that tax payment comes in, it comes in from Airbnb. It does not identify the individual owner who rented that unit or that house as a short-term rental. That agreement, which I have a copy of if anybody wants to see it, also states that even if the city wants to audit the payments that Airbnb submits on a monthly basis, that is done on, this is a hard word for me to pronounce, an anonymatized basis. That's the word in the agreement. So therefore, even if the city wants to audit, they're just auditing what Airbnb collected and remitted, not on a owner-by-owner basis. It's all anonymous. Therefore, the argument that, well, the city knew that this piece of property here, owned by the applicants, was being used as short-term rental doesn't hold water. The city had no knowledge through the payment of taxes by Airbnb that this property was being used for short-term rental purposes. It's true, as Ms. Kamanis told you, that the old zoning ordinance did not identify short-term rentals as a permitted use. But the old zoning ordinance, like the UDC now, provides direction as to how the staff handles uses that are not listed within that chart of permitted uses. And what it says is, had the applicants come to staff in 2018 when they wanted to open up this short-term rental and asked for zoning clearance or just to check on the zoning of the property for the guest house garage apartment, the staff would have looked to the section that says how you handle uses not listed. And in that zoning ordinance, it directs staff to make a determination for any use that is not listed, and that determination should be. Did I do that? That determination for any use not listed is based upon the similarity in nature and character to one or more uses that are listed in the chart. So what uses in the chart of permitted uses under the old zoning ordinance are similar in nature and character to the short-term rental that the applicants started operating in 2018? And I'll submit to you that the answer is inherent in what they call their business. They call it an Airbnb. And what does the B&B part of that mean? It means bed and breakfast. You go back to the beginnings of Airbnb, that's how they advertised themselves. That's how they conducted their business. It was a bed and breakfast. The zoning ordinance does have bed and breakfast listed as a permitted use within that chart. It defines bed and breakfast as a house or a portion thereof where short-term lodging rooms, with or without meals, are provided for compensation. Where short-term lodging rooms are provided for compensation. It sounds like a short-term rental because they're almost identical. But the important part here is that a bed and breakfast was not permitted in an R1 residential district. So had the applicants come to the City of Mobile staff in 2018 when they started their business and asked, can we do this here? They would have been told, no. Even though you're not listed in the chart of permitted uses, we go back and we look and your business is similar in nature and character to a bed and breakfast, and you cannot have a bed and breakfast in an R1 district. R1 districts, as you know, are described as one family or sometimes single family residential districts. They're intended for one family dwellings. And the regulations say, and I'm referring to the old zoning ordinance here, that they're designed to protect the residential character of the area. What is a one-family dwelling? As defined by the ordinance, it's a building containing one dwelling unit and used for residential purposes exclusively by one family. Residential purposes exclusively by one family. You then have to, let's go through a series of definitions here. Family is defined as one or more persons living together as a single housekeeping unit. That can include boarders. You can have a family who rents out a room to a boarder, but the requirement that the people that live in that home live together as a single housekeeping unit is a requirement to be a single family home. The old zoning ordinance also defines dwelling unit and requires that it states that a dwelling unit is a separate, independent housekeeping unit for permanent residential occupancy. Important phrase there. Not only the housekeeping unit, but for permanent residential occupancy. The courts have looked at the meaning of all of these terms. And, you know, courts in other jurisdictions that have handled these issues involving short-term rentals have stressed that the definitions require that the occupants live and behave in a manner like a family that is permanent and not transitory. That accepted definition of a single housekeeping unit means that the composition of the group must be sufficiently stable and permanent so that it cannot be characterized as purely transient. The ordinance here clearly and unambiguously excludes purely transient uses of property in a single-family residential district. Like I said previously, you couldn't have a bed and breakfast in a single-family residential district. You can't have a hotel or motel. There's no ambiguity here as to the definition or the application of those terms that require single housekeeping unit and people that live there on a permanent basis. Which brings me to the October 2023 decision of the Alabama Supreme Court in the case of Dixon versus City of Auburn. Mr. Dixon, ironically, was a member of the Auburn City Council. He bought his house in 2018 and started using the basement part of it as a short-term rental. Short-term rentals, like Mobile, were never listed as a permitted use in the Auburn zoning code. Mr. Dixon, like the applicants here, never requested an interpretation from Auburn's staff as to whether his use of that property for short-term rental was allowable. And he also argued, well, Airbnb's been submitting taxes, to the city of Auburn on my behalf for a number of years. He made all those arguments in support of his non-conforming use request because 3 years after he bought the property and started using it, and he started using it as a short-term rental in 2018, these applicants started theirs in 2019. The city of Auburn enacted an ordinance that prohibited short-term rentals within the district where his house was located. The court concluded that Mr. Dixon was not entitled to non-conforming use status. They said all of those arguments that he made, that he was using the property prior to the ordinance that prohibited short-term rentals in that district, that short-term rentals had never been mentioned at all in the Auburn zoning ordinance, and that he was paying taxes through the Airbnb tax collection agreement, which is pretty much identical to what Mobile has, that all of those entitled him to non-conforming status. The Alabama Supreme Court said no. The court, I'll quote here, said that Mr. Dixon failed to show that his short-term rental use was lawfully established before the city's adoption of the short-term ordinance. Court also pointed out that he started using his property in 2018, which was prior to that agreement where Airbnb started anonymously making tax payments, and therefore he could not have relied upon that agreement as a ground for his non-conforming use status. Same thing applies here. These applicants in their letters state they started using the property as a short-term rental in 2018. The agreement between the city and Airbnb for anonymous tax payments is, I know it's 2019, I think it's April of 2019. Let me sum it up this way. The garage apartment that the applicants use for 2 short-term rentals on a separate, this thing just doesn't like me, does not qualify to be a non-conforming use. It is not allowable in an R1 district under the old zoning ordinance. The people that use it are transients, travelers, people that come to Mobile on business, go to a graduation at South, go to a high school graduation, come here for a wedding, whatever. They come, they stay for 3, 4, maybe 5 days, maybe a week. Very similar, if not identical, to a hotel. The use of the property is not a single-family residence. When I say property, I mean the garage apartment. And it's not used or occupied by people that constitute a single housekeeping unit on a permanent basis. It might have single housekeeping units come there for 3 days, and then you get another one coming for 3 days, and you have a break, and 2 weeks later, another single housekeeping unit comes. A family comes and uses it. That is not what our zoning laws state and require. Let's look at it this way. The house that my wife, my children, and I own and live in is a single-family residential dwelling unit. That's where our single housekeeping unit is set up. But if I take my family on vacation to Disney World and I stay at an Airbnb, that's not my residence. Same thing applies here in Mobile. Somebody that lives in, name a city, Cleveland comes to mind, comes down here to Mobile for a wedding. They rent this Airbnb from the applicants for a long weekend. That's not their residence. They're not permanent residents of that structure, and they don't qualify, well, their use of that property on a transient basis does not qualify that to be a single-family residential dwelling unit allowable in R1.
Mr. Rossler, if we can summarize.
Sure.
Yeah.
And I am at the end. Let me just end with this. The city council worked on this ordinance. When I say ordinance, I mean the short-term rental ordinance for quite a while. They anguished over it. They debated it. They came up with a requirement that requires any short-term rental unit to get conditional use permitting, which requires that each one of them come to the city council. They did that because there are problem units out there. I could identify for you right now some where there's been repeated criminal activity, repeated problems with large-scale properties. I'm not saying that these applicants are guilty of any of that, because I doubt that they are. But allowing non-conforming use, in this case, sets the precedent for all the rest of the short-term rentals, thereby defeating what the city council intended to do, which was to address them on a property-by-property basis so that they can put terms and conditions on the usage. And the UDC lists numerous terms and conditions that would be put on use, and also to address the problem units. So I'll just sum it up with one sentence. Under the old zoning ordinance carried forward to the UDC, these applicants are not entitled to a non-conforming use status.
All right, any questions of the board for Mr. Rossler?
I've got a question. So prior to the UDC, if somebody wanted to have an Airbnb at their property, how did they go about doing that? They went through and made application to the city, and then the city would make a determination of whether they qualified or not, based on your
Yes.
explanation
Would
before.
look to that language that says they have to
Not
consider the
similar
most
things to the
similar
perimeter.
in nature and character. And that leads them to bed and breakfast, which is defined, lose my voice there, which is defined in terms that I can go back and read it for if you want, Mr. Milling, but it's so close to a short-term rental, they're almost identical, and probably are identical. And they would have been told, sorry, can't have that in R1.
And this may be running a little bit down a rabbit hole, but I'm just from prior applications and things we've had with accessory buildings that have kitchens or not kitchens or stuff, and kind of running down that trail of the Airbnb with the bed and breakfast side of it. If there was a determination that there really, there was no cooking type apparatus or anything like that, but it was just a place for somebody to stay for a night or two, would that have made any difference at all in that determination? I guess what I'm getting at is trying to separate it. I mean, Airbnb to me may be just kind of a marketing type thing as opposed to a practical use of the property as both a bed and a breakfast type place. And so I'm just trying to understand if the city was trying to make that determination at the time of those similarities, would, if you weren't serving breakfast or having that type, it was more just a place you go spend the night, then you head out to, have breakfast, do whatever, and then go back. Would that have made any difference?
I don't know that it would.
Okay.
Because the definition of bed and breakfast that I read to you is a structure that provides accommodations with or without meals.
Okay.
But I will say this. If you go back, like I've been forced to, by my clients here as we researched this and look at the history of Airbnbs. And I'm including within that Verbos and other platforms. But let's deal with Airbnbs. They started off where an owner had a home and they had a spare bedroom, had a basement, had something that they wanted to rent. And they have now morphed almost completely away from that model, where it is impossible, I should say near impossible, because I can't find any, where people have an Airbnb where they're renting a room or 2 rooms in the home that they live in. These are all separately owned homes, many of them out-of-state owners, many of them corporate ownership, owned by companies that buy them and operate them not only in Mobile but other cities all over the Southeast as short-term rentals. So that it's really morphed, completely away to what your example was, Mr. Milne.
And so then fast forward, when the UDC was passed, anybody who has an Airbnb has to come to the city council to get approval for that?
Yes, sir. Get a
Okay.
conditional use permit.
Okay, thank you.
Okay, any other questions?
I'll follow up.
So,
on
Mr.
that.
Golden.
Have people come and gotten conditional use permits? I mean, has that happened? Do we know how many?
That process just started getting enforced in October, November. We've had one go through the Planning Commission and is under submittal to the City Council at this point in time. And Stephen can give you a more up-to-date answer to that.
Yes, so the conditional use permit goes to planning commission. We've had one come to the planning commission, and Marie has held multiple pre-development meetings with other short-term rentals to walk them through the process, as well as the requirements that the city council set forth in the UDC.
Okay, that's helpful. And then one last, so I'm showing the garage and the house on one parcel. I mean, I get that it was probably originally 3 lots when subdivided 100 and plus years ago, but City of Mobile recognizes that as one parcel. Is that right?
No. There are 3 legal lots of record. The 2 lots facing Spring Hill are lots 1 and 2 of Park Place. And the one, I would say to the north of that, is lot 3. And Ms. Commandus in her letter last Friday states that this structure is on its own separate legal lot, which would leave lot 3 at the top. That lot has a Park Avenue address, and the house facing Spring Hill has a Spring Hill Avenue address. That's just a tax parcel, not a legal lot of record.
Yeah, okay. So it does, their letter says sits on its own lot of record, but when you pull up GIS, it does show one tax parcel.
And so something that I learned, and I didn't know this until just recently. When you pull up that city GIS map, that is showing tax parcels, not legal lots of record.
And it shows, I believe, the lot lines. So, I mean, it's, yeah. Okay, thank you. Okay, thank you. Right.
Mr. Atchison, you had a question?
Yeah, I have a quick follow-up to Lewis's question. So if it was one legal lot of record, would it have still qualified as an accessory use, or is that a moot point?
I think it's a moot point.
Okay. Because you started talking about the legal lots of record, but then you kept going to where it didn't sound like that would be an allowed use either way.
No, agreed. Because they've said it's on its own separate legal lot of record. It cannot be an accessory use, but even if it was on the lot with the main house, that does not qualify as single-family residential dwelling unit under the definitions.
It wouldn't be allowed as an
Would not be
accessory
allowable.
use because it's a separate structure, or because
Well,
that use is not allowed
because
in
that
R1,
use is not allowed in an
regardless
R1.
if it's accessory or the main use.
Correct.
Is your opinion?
Yes.
Okay.
Okay, any other questions?
Thank you, board members.
All right, yeah, we're going to give you ample time to respond.
Thanks. The the three lots of record, or the three lots from that old subdivision are what they are. Our point in bringing it up is that we've got this mix. You can see on the graphic, the main house that fronts to the south looks like it's sort of straddling two of the lots. And the one in the rear looks like it might be straddling two of the lots. Maybe it's further north than that shows. But the deal with accessory structures and accessory uses, Mr. Atchison, or Chair, the definition from the 18 code, accessory structure, a detached subordinate located on the same building site with the main structure, the use of which is incidental to that of the main structure. And so it doesn't talk about legal lot of record and this lot of record thing that the city of Mobile gets hung up on, where you have to have a subdivided lot to do anything, and that's a legal lot of record. It talks about a building site. We've got more than one lot where my building is across the street, but it's one building site where we've got this structure and we've got the parking facility that goes with it. And this is one building site. It's been used in this way for a long time. And what our clients were doing was renting out this back house, carriage house structure incidental to their owner occupancy of the main structure. And it was a rental for years since they bought it. And people renting a residential structure, and these have kitchen and whatever facilities, they're like little apartments that they were renting out. And in 2018, when they switched to the short-term rental model instead of the whatever longer duration it was and put it with Airbnb, the city didn't have anything that said, well, you can rent this out, but only if it's this long in time and not that long in time. And that didn't come about till later. And so we don't have to go to the city and ask for an interpretation of, hey, we've got this guest house we've been renting out for the last however many years, but now we want to rent it out for shorter periods of time through this online thing instead of through word of mouth or however they did it here. They don't have to ask for that. And so they didn't. They didn't know that there was anything they needed to do differently. But I don't think the city got on board to regulate short-term rental until later. They had an ad hoc committee studying it for a few years. They have these announcements of public meetings that the ad hoc committee was going to have where you could listen but not talk. Didn't bother to go to any of them. But it was something they were studying. They were trying to figure out what to do. They were looking into it. And then they ended up rolling it into the UDC with a lot of other zoning changes that were being considered at the time. And I'm all for regulating short-term rentals. I think you've got to recognize, though, that there's some water that's gone under the dam before the UDC was adopted in 2023. And if you say, well, we don't like all these neon signs, well, that's fine, but you got a lot of neon signs already in town, or you've got a lot of whatever it is the city might want to start regulating. And that's where this legal nonconforming issue comes up as a matter of law, where you have a vested property right to continue to use some structure that may violate the code, or to continue to use some use of your property that you've already established. And this is what is in the UDC. There's a nonconformity section, and it says just that you can continue to use these things, structures and uses that were in existence. I think this issue about it's on its own lot of record, therefore it can't be an accessory use, is something that I'm hearing for the first time today. And I don't think that is what the definition of accessory structure means in the 2018 code. And I don't think it has any application to this. We had a back house that was being rented. It was all being used for residential use. This wasn't like somebody operating a dentist shop or a business in a residential area. It was all residential. Some people were staying longer than other people. at some point in the lifespan of this thing, but that was before the city started regulating rental properties based on how long they were there, short-term, long-term, student, guest from Cleveland, whatever it may be. To the point that the city doesn't know that this was operating as an Airbnb. They knew enough to write our client a letter and say, hey, we're reaching out to all the people that operate these things, tell you need to get a business license because we passed a new ordinance that requires a business license for these things. You know how they can find it? They go to Airbnb's website. I mean, they're all there. Just search by the city. You got them all right there. And so we were, while the amount of the tax being remitted by Airbnb might have been anonymous, it was not going to be hard for anybody at the city to go figure out where are all these Airbnbs. I mean, we don't know that it's the March House that's remitting some portion of this tax for the past month, but we know it's available on Airbnb because we can see it on Airbnb. No one was hiding this use. And I would submit that if renting your back house out was allowed in 2018, which it was, and there was nothing that specified, well, you can rent it, but only if they're going to be a resident, you know, for at least 6 months or 9 months. There was nothing in there about duration. If a rental of a back house was okay in 2018, then a rental of a back house on an Airbnb platform was okay in 2018. It did not become a bed and breakfast use. It was a rental of a back house either as an accessory use or under the city's definition of family that includes up to 4 or 5 unrelated people, whatever you wanted to do, but it wasn't going to go through a bed and breakfast analysis. Those are a different level of commercial appeal or commercial impact. I think the Dixon case is going to be the leading case on the subject to the extent y'all want to read it. It had a very specific finding. The applicant himself admitted that the use wasn't allowed when he created it. Here, we don't have that. We think it was allowed. The city says, well, maybe it would or wouldn't if it was on its own, wasn't on its own lot of record. I'm not sure. But we definitely have a dispute. We think this was allowed by right in 2018 and before, but we weren't doing it until then. Because rental of back houses is happening all over the town, all over the place. And rental of standalone residential properties, whether it's owner occupied or tenant occupied, that happens everywhere, all the time. So we think this one was allowed by right when it started, and under the city's own zoning ordinance, you've got to recognize those things. And the reason you've got that in the zoning ordinance, that you recognize legal non-conforming uses and legal non-conforming structures and lots of record and that kind of thing, is so you don't run into a regulatory taking problem where you've got an ordinance that prohibits some property right or some use of your property. And that's the point of these legal non-conforming sections in zoning codes, and that's why it's in the UDC right now. I don't think it's up to the city, no matter how much they may want to get their arms around the short-term rental industry now, to just go back and ignore the previous users of that property. Now, the UDC will grab everybody new that comes along, everybody that doesn't have a legal non-conforming use. If I wanted to go buy a house and start using it as an Airbnb, I'd have to go to the city and get a business license and get a conditional use permit and follow that process. But the people that have already established that use before 2023, those people are, I think, outside the scope of this UDC conditional use permit. And so, no, we did not apply for one. We applied for recognition as legal non-conforming status, and which I think is the avenue open to everybody that had a previous use like the March family did.
Casey, can you, I'm sorry, were you through?
I am, thanks.
Okay. This, we all know these diagrams are not exactly accurate. Is the garage on that northern lot, or is it on the lot to the west?
We believe it's on the northern one.
Yeah, okay. And the reason I brought that up about legal lots of record and that lot having its own address, this owner and any future owner could sell that building by itself.
Okay. Any questions for Mr. Pipes?
I have one.
Yes.
What date and time did the city inform the Dixon family that they was reaching out to them for understanding on their new laws regarding that service they were providing?
The March family got a letter from the city in October of 2024 explaining that there was a new regulation and that short-term rental operators had to get a business license at each address. And that previously was not required by the city. And so this was a change to how the city was going to be regulating this industry of making them come and get a business license. And it's my understanding that the city, because we got several calls from a lot of different people, some were on Airbnb, some were not on VRBO or Airbnb, just they were providing rental accommodations in town through some type of other system, that all these people got letters. It must have been some targeted mail out based on people that were using their property as a rental, a short-term rental, through what the city was able to discover through the online records. So that was sometime in late 2024, Mr. Morris. We then applied for the recognition as a legal non-conforming use in early 2025, and that was the request that was denied, not citing a reason as to why it was denied, and that's what led to this appeal.
Hold on before, any other questions?
I've got a question or two.
Yes.
Casey, prior to 2018, were they strictly just leasing it as longer-term rentals, or did they have shorter-term in there? It just wasn't on an Airbnb type platform?
It wasn't on an Airbnb, one of those kind of platforms. I would imagine, they bought it in 2009, and I just don't know what the shortest rental period was they had between 2009 and 2018. It was just in 2018, and we thought it was originally in 2019. It turns out it was in 2018 that they put it on this Airbnb platform.
But as far as you know, there wasn't kind of a strict rule that, hey, I'm only going to lease to people if it's 6 months or more or something like that. I mean, it very well could have been people coming in for a wedding or whatever. It's just at that time period, they went strictly to a more organized platform.
Yeah, I mean, just the marketing, got different. I think I would imagine the market for that renting out your back house changed when everybody else is on Airbnb and you're still doing word of mouth. But yeah, there was a question about comments from the neighborhood. I think most of the neighbors in this area use this when they have family or extended family coming in from out of town to put people that are visiting them closer to wherever they live. But, we don't have we haven't heard of any opposition from the neighbors about it. But I think it was, probably a mix of different duration of tenants they had over time. I don't know what they had, but they certainly didn't have a policy or a rule.
Mm-hmm. And then prior to, I guess, that organized platform, was there a system of which they would pay any type of lodging tax to the city, or that was just an income tax or something?
No, they would have accounted for it as income,
Yeah.
but not lodging tax to the city. I think the city's lodging tax ordinance, I don't know when, they would know, but I don't know when it would have become applicable to a rental of a garage apartment.
Okay. And then last question is, why did they choose to go the non-conforming route versus to just go and apply for, a permission to use it?
Yeah,
Was there concern that they wouldn't?
well, at the time, it was funny. This client called, one of the first clients that called me about this. I thought it was, the city wants you to get a conditional use permit, but the way I understood the timeline of the facts, this client would have been grandfathered, so I just suggested they apply for recognition that way. Later, in context with a different client I have, I spoke with Mr. Rossler about them, and he informed me that everybody was going to have to get a conditional use permit. Even, because I had another client that had some that predated the ordinance and some that didn't. And I thought they might be in two different buckets. And he advised me that that was not the city's interpretation and that everybody was going to have to get a conditional use permit. And at that point, this application for legal nonconforming status was already pending at the city. But the conditional use permit process is concerning. In answer to your question, it wasn't why we are here as opposed to there, but it is a very discretionary approval. You send notice to the neighbors. You have a neighborhood meeting. You go to the planning commission. There's a public hearing. You go to the city council. There's another one. And then there are a bunch of conditions that can get imposed on it. And so to me, if you've got a vested property right as a legal non-conforming use, you do not want to run down that rabbit trail of going in and getting possibly denied or possibly conditioned, approval on something where you're adopting new conditions that aren't subject to you. Now, to the issue of bad actors, I'm sure there are some properties that are causing a problem. The city has plenty of power to revoke a business license, to do other enforcement action. And our client's not opposed to getting a business license. You can't get a business license until you get conditional use permit under the city system. So we can't get a business license until we get past either this hearing or that hearing. But the city has plenty of powers and does it, I wouldn't say all the time, but has the power to revoke a business license that's not being operated in a way that complies with code or that's constituting a nuisance. They can pull the business license and take a use away, but that's not what we're here about. And we'd still have to go get a business license because we're not grandfathered from having that happen, and we'd be subject to the regulation through the business license ordinance, just like every other business owner is.
Do we have any other questions for Mr. Pipes? Okay. Do we have any others that wanted to speak on this matter today? All right, I have a question for Mr. Anderson to help the new board members and those of us that still struggle with this. Explain the administrative appeal process, what we're doing here today and what we're being asked.
Sure. This is not historically usual, but it's been on the books for a long time. If someone, like this applicant did, comes to the staff's office on the third floor and says, I would like an interpretation, or I would like this kind of permit, and they say no, because of A, B, or C, we cannot do that for you. They can, are we non-conforming or are we legally compliant? And if the staff says no, they have the right to appeal the staff's decision to you. It's not done frequently, but we've had them before. But it's like I said, it's been a part of the zoning ordinance for a long time.
Okay, the next part of this is, let's say we either uphold the staff's decision, or we go in support of the appeal, and the applicant chooses to take it to the next level, what would be the next step if they don't agree with the board's decision?
If y'all uphold the appeal, uphold their decision, staff's decision, and say they are not non-conforming, then the applicant would have the right to appeal that to circuit court.
Okay, I just want to make sure everyone here understood that.
Yeah. One thing I would like to add while I have the mic, this is a very unusual situation. Most of your decisions affect one property or the property next to it. This is a decision, as it's stated in the staff report, that can affect every owner of short-term rentals in the city. So I would ask that if any person on the board has short-term rentals, that they recuse themselves, because they could benefit financially from this decision. And we don't want to have any looks of impropriety. So if I would ask that you ask your board members, and if they do, that they recuse themselves. Yeah, but if you don't agree with that, I understand, but that's the legal interpretation I'm giving you.
Mr. Golden, you had a question?
I did, Doug. So we know what they can do if they don't get the answer they like. In the city, if they, if we reverse their decision, does the city have a position to appeal it also, or is?
No. I don't think we do. We do? Okay. All right, yes. Your staff is appealing its board's decision, yes.
Just, wanted to make sure I understood. I mean, it seems like you would have that ability, so.
Yeah. Question, Doug.
That's a new one on me.
So, I guess taking into account the weight of what you said with regards to, the ramifications this decision could have with regards to a lot, setting a precedent for a lot of other properties. And, having heard both sides today, do we have the ability to hold it over to do, if we wanted to do additional, research on it, or, read some of the things that have been cited and things like that?
That's always within your discretion.
Okay, thanks.
Okay, any other questions, comments from the board? This, as stated, this is a very unusual process for this board. I cannot remember maybe half dozen of these appeals over my time on the board. And always the legal guidance is important for all of us, both sides of an appeal. So we have to take that in consideration. And then, now I would say regarding precedent, we still have to look at each one individually. Each one, the case and the facts are specific to the appeal or not. They may not be similar, but, rental or short-term rental and all those standards will probably apply going forward. So,
now, one more thing, I should have mentioned this earlier. In your staff report, it has the standards for your decision on this kind of appeal. So on the page 4 of 9. So look and see, look and read those 3 criteria assist you in your decision-making process, please.
So Doug, if I have some rental property that we signed a 5-year lease on and they only made it a month or 2, can I recuse myself as a short-term rental guy?
No. You got one in your backyard, yes.
All right. I am going to heed Doug's advice and recuse.
all right, thank you.
Thank you for that knowledgeable information. I'll recuse myself as well.
All right. The 2 members come into play.
All right, so we have 6 remaining. Are you going to recuse yourself too, Mr. Al?
No, sir, I had a question.
Yes.
We had a future land use map in here. Is there anything?
Pull your mic closer.
Is there anything in the future that, with it being on Spring Hill, let me make sure I'm on Spring Hill Avenue, all of those properties that are facing that street, is there anything in the future that's going to change that R1, or is the city going to do anything with that because it is a main corridor there?
The city is not going to proactively change any zoning based on the future land use map. That is just a guide that can be made available to the planning commission when they consider rezoning requests that are submitted by property owners. So the city will not itself do it.
Okay, any further questions? Okay, as Mr. Anderson stated, there are some conditions we should consider. Whether there was an error in an order, requirement, decision, or determination made by an administrative official. 2, whether the decision was a result of an arbitrary or capricious interpretation of the requirements of this chapter. Or 3, whether the decision was an incorrect interpretation of this chapter. If the board shall render a decision based on the findings of fact supported by evidence in the record, they may reverse or affirm wholly or partly the decision, or modify the order, requirements, decision, or determination appealed from. Make such order, requirements, decision, determination as ought to be made. To that end, shall have the powers of the officer from whom the appeal is taken. I think I covered everything that was listed. All right, comments of the board? Any further comments or statements?
I will just follow up on my previous comment, Mr. Chair, that I think, there are statements from both sides that, I have heard and at the time agree and sound logical, but, in stating documents and kind of the interpretation of those documents and the weight of the decision we're making, I would prefer it be held over for 30 days so that, I personally, in voting for it, one way or the other, could have the ability to go back and review several of the items that were, stated in support or opposition of the request. So that's just my personal opinion.
Okay, so in the form of a motion, you're requesting a holdover 30 days?
Correct.
Okay, I have a motion for a holdover 30 days. Do I have a second? Chair will make a second. I'm also leaning towards some more fact-finding and educational material. I have a motion with a second. Any further discussion? All those in favor of the motion say aye.
Aye.
Anyone opposed?
Opposed.
I have one opposed, so the motion carries with 5 in affirmation. Mr. Morris in opposition.
And I'll just follow up and say, I think that there's rarely an intent to draw something out, but I feel like from our standpoint, at least from my perspective, you have some experts here in front of us that are, giving us their professional opinion of why it should be one way or the other. And I just find it personally hard to make an informed decision with the consequences that our decision could have just based on, 45 minutes to an hour of arguing one way or the other. So that's my position on holding it over.
Mr. Chairman, to better answer your question, what can they do? They could appeal to circuit court, or they could apply for a conditional use permit.
Okay. All right, so motion to hold over 30 days passed. So we'll conclude with that application or that appeal at the moment. And let's see, for the benefit of the group, do we have any legal updates, Mr. Anderson?
No, sir. We've got a couple. We've got a couple appeals, non-jury, that are pro se, couple of applicants that the one on at the Loop with the what's the name of that building? Yes, Pops Midtown, where Renita Smith across the street appealed that approval. That one's coming up for summary judgment pretty soon. And there was another one that we didn't get notice of the appeal, and the default judgment was filed. And we filed a notice of appearance, and the judge set that for trial in June. And that was a gentleman who was going to do AC repair in his on his residential lots in the neighborhood. and expanding one, if I remember correctly.
And we had two others. We had the St. Ignatius with the cemetery.
Yeah, that, both the other attorneys have been out of the country for a couple of weeks, must be nice. That is set on the church's motion for summary judgment later this month.
And then the bus storage at the church property.
Oh, the one on Texas Street?
Yes.
Yeah, that was approved by the Supreme Court. I thought I reported that previously, because Reginald Hill had appealed that. And, yeah.
So it was upheld.
That is, y'all's decision was upheld, yes.
Okay.
Doug, when those are appealed, like the Pops Midtown, for example, does Pops have to hold off doing anything until that appeal is heard and
Correct.
a decision is
Yes,
made?
they can't get any kind of permits if you deny something. Well, any appeal, whether it's approved or disapproved, the application process is stayed until the appeal is finalized.
Okay, I've got one other thing. So my understanding, HB 281 was introduced at state legislature, which is to help define the rules regarding appeals and timeframes. Have you seen that, Mr. Anderson?
Somebody from either the staff or Board of Realtors sent it to me.
I have a copy of it.
Yeah, I've seen it, but I don't know. I received a copy of it like 2 weeks ago, I believe, and this session is ending tomorrow.
3 days, yeah, a couple days.
Yeah, this week. So I'm not sure the status of it, but I was aware of it.
Yeah, it would be effective October 1st if it's signed. Okay, any other, I have minutes.
Minutes?
We had minutes that were sent out. Any corrections, modifications to the minutes? All right, Chair, I entertain a motion to approve the minutes as presented.
Motion to approve the minutes.
Have a motion, do I have a second?
Second.
Second, any further discussion? All those in favor, say aye. Aye. Okay, minutes are approved as presented. And thank you again to our new members and supernumeraries. And with that, I'll conclude our meeting.